Hello, everybody, and welcome to History/Law Bite number 289, dated July 20th, 2021. I'm Walter, your mobile historian and blue-collar scholar. Thank you for tuning in. As you have arrived at my channel, I humbly invite you to subscribe. Just hit that little red subscribe button at the bottom right of your screen, as well as that little notification bell so that you may be informed when I post new videos. And believe me, all of them are good. And I thank you in advance for your support. So, this History/Law Bite is entitled Yick Wo versus Hopkins, 118 U.S. 356, 1886. I think it's a pretty safe bet that if you're here watching this video today, you probably don't know a lot about this landmark U.S. Supreme Court decision. Or maybe you know a little something about it and maybe need some further help or clarification. In any case, that's why I'm here to help you along. All right? So, in Yick Wo versus Hopkins, the U.S. Supreme Court established a very important principle in constitutional law. And that principle was as follows: that facially neutral laws that are applied in an unjustifiably discriminatory manner between persons in similar circumstances violate the 14th Amendment's Equal Protection Clause. Okay? That alone suggests just why, point blank, this case is so important. Because so many laws are written with innocent, neutral language, but are indeed applied in a very discriminatory format. All right? This case, all right, established the principle in constitutional law, at least in theory, that wasn't okay. So we begin Yick Wo versus Hopkins, as all U.S. Supreme Court decisions begin. All rise. The Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Please be seated. Mr. Chief Justice, and may it please the court, we present Yick Wo versus Hopkins. So in this case, ladies and gentlemen, we see, first a little context and background, this case came about as a result of the large amount of Chinese immigration to the West Coast, and more specifically the state of California, between the 1840s and the 1870s, okay? Many of them came here during the gold rush in the late 1840s and early 1850s, okay? They certainly found work during, that, monumental event in American history. And these Chinese immigrants, certainly, many of them became, very wealthy as a result of becoming business owners, okay? And as you would expect, okay, there was a tremendous amount of xenophobia against the Chinese in their culture on the West Coast, okay? Something that bore its head with the infamous Chinese Exclusion Act of 1882 from the Congress, right? That was one of the most blatantly xenophobic federal laws ever enacted, okay? So there was a lot of hostility to the Chinese on the West Coast. The rest of the country really wasn't concerned about them because most of them settled over in California, okay? So it wasn't really a big issue, but there it was certainly a big deal, okay? And another reason, of course, that, the Chinese were very resented was the fact that they provided a substantial amount of economic competition to the whites. So you know there was bound to be conflict, all right? Many of the Chinese operated laundries. Yes, laundry is a laundry, okay? And many of those laundries became very profitable, okay? Certainly challenging the ability of the white laundry owners to have dominance, okay? Most of those laundries tended to be operated out of wooden buildings, about 95% of them in total, of the city's 320 laundries. You might not care about that right now, but you'll see the relevance later on, okay? So, in an effort to curb the power of the Chinese, the city of San Francisco enacted a facially neutral ordinance in 1880 whereby all the laundries in San Francisco that were operated out of wooden buildings would need a permit issued by the city council, which in San Francisco is known as the Board of Supervisors. The Board of Supervisors had absolute discretion to decide who would be and who would not be granted a permit to operate a laundry in a wooden building, okay? Now, the publicly declared intent of this law was to ensure compliance with the city's fire code, all right? But the real intent of the law was what? Exactly, to wipe out the economic competition from the Chinese. So, as we have seen, the law was facially neutral. Everybody who operates a laundry out of a wooden building has to have a permit. Innocent, right? Maybe not so much. Facially neutral, yes, but its application, ladies and gentlemen, was anything but fair and neutral. At this point in the 1880s, Chinese owners operated roughly 89% of the laundries in San Francisco, okay? Most, of course, which were in wooden buildings. And when it came time to apply for the permits, guess what? Only one Chinese owner of a laundry operated out of a wooden building was granted a permit. What a surprise. By stark contrast, all of the white owners, except one Belgian woman, were granted permits. What a surprise. So, everybody, however, wasn't Boo Boo the Fool, as they thought they would be. Our petitioner, Yick Wo, and related Wu Li, operated laundries in San Francisco without these required permits. They said, damn the law. With all due respect, this is blatantly racist and discriminatory. San Francisco, you're giving all the permits to the white laundry owners, but you're not giving any to the Chinese laundry owners who have operated laundries here for decades without any problem. The only problem is we're providing too much competition to the whites, therefore we must go. So they weren't about to take that lying down, okay? So they operated their laundries and said, do what you will, San Francisco. As such, both men were fined $10. While that ain't a lot in today's money in the context of the 1880s, that was roughly $270 apiece. A little bit more, isn't it? So, Mr. Yick Wo and Wo Li refused to pay these fines, all right? And Peter Hopkins, our respondent in the case, arrested them and placed them in jail, okay? And as a result of their detainment, Mr. Yick Wo and Li sought writs of habeas corpus, okay, challenging the legality of their imprisonment on all grounds. The men argued that both the fine as well as the selective and highly discriminatory city ordinance violated their rights under the 14th Amendment's Equal Protection Clause. These men were well aware of their rights. Okay? Which is a good thing. Otherwise, who knows how long this would have gone unchecked. So, in advancing through the courts, the Supreme Court of California, as well as the U.S. Circuit Court for the District of California, both affirmed the constitutionality of the city ordinance because it was facially neutral and thus, in their eyes, non-discriminatory in practice and application. Ha ha ha! If only. The matter would soon then be appealed to the Supreme Court of the United States. When the matter was argued, the justices would face a very clear, and if you ask me, very easy issue. And that issue was, in spite of San Francisco's ordinance containing the neutral language, okay, did the discriminatory application of that ordinance violate the 14th Amendment's Equal Protection Clause? So, in spite of the fact that the statute had neutral language, did its discriminatory application violate the 14th Amendment? Okay? And the court ruled in a unanimous opinion that it absolutely, positively, beyond all doubt, did indeed violate the 14th Amendment's Equal Protection Clause. In a unanimous opinion written by Justice Stanley Matthews, arguably the only opinion that he wrote with any lasting significance. The opinion reasoned quite brilliantly that, number one, in spite of the law's neutral language, the biased and discriminatory application clearly violated the Equal Protection Clause of the 14th Amendment. Number two, even if a law is facially neutral, if it is applied and administered by public authority with an evil eye and an unequal hand, so as practically to make unjust and illegal discriminations between persons in similar circumstances material to their rights, the denial of equal justice is still within the prohibition of the Constitution. Number three, the resulting discrimination, which was experienced by the petitioners, amounted to a practical denial by the state of that equal protection of the law, thus in contradiction of the 14th Amendment. And number four, the ordinance of the city of San Francisco was therefore unconstitutional, and all charges had to be dismissed against all individuals fined and jailed under San Francisco's ordinance. So now read an excerpt from Justice Matthews' opinion. This conclusion and the reasoning on which it is based are deductions from the face of the ordinance as to its necessary tendency and ultimate actual operation. In the present cases, we are not obliged to reason from the probable to the actual and pass upon the validity of the ordinances complained of, as tried merely by the opportunities which their terms afford, of unequal and unjust discrimination in their administration. For the cases present the ordinances in actual operation, and the facts shown establish an administration directed so exclusively against a particular class of persons as to warrant and require the conclusion that whatever may have been the intent of the ordinances as adopted, they are applied by the public authorities charged with their administration and thus representing the state itself, with a mind so unequal and oppressive as to amount to a practical denial by the state that equal protection of the laws, which is secured to the petitioners as to all other persons by the broad and benign provisions of the 14th Amendment to the Constitution of the United States. Though the law itself be fair on its face and impartial in appearance, yet if it is applied and administered by public authority with an evil eye and an unequal hand, so as to practically make unjust and illegal discriminations between persons in similar circumstances material to their rights, the denial of equal justice is still within the prohibition of the Constitution. So the judgment of the court overturned the Supreme Court of California and the U.S. Circuit Court for the District of California. So the legacy of Yick Wo, though, is not so glorious, unfortunately. You know, in spite of the profound precedent set by Yick Wo, you know, that facially neutral laws that are applied in a discriminatory manner violate the Equal Protection Clause, in spite of that wonderful precedent, the case lay dormant for quite some time after it was handed down, you know. Ironically, folks, when the opportunity came about just 10 years later in Plessy versus Ferguson, we all know about that one, which is covered in its own video, in 1896, when the opportunity came about to apply Yick Wo against Jim Crow laws that discriminated against African Americans, all right, the court refused to invoke Yick Wo as the guide for Plessy versus Ferguson, in spite of it being a clear precedent to hold segregation unconstitutional. Okay? It would not be until roughly the 1950s, under the Warren Court, ladies and gentlemen, when Yick Wo would be fully realized, okay, and applied against discriminatory laws inhibiting the political and civil rights of African Americans, okay? And to date, as of 2021, Yick Wo has been applied hundreds of times now, well after it was handed down, against facially neutral yet unjustly applied laws, okay? Giving the precedent its true force, okay? So that's Yick Wo versus Hopkins, ladies and gentlemen, 118 U.S. 356, 1886. And remember, the summary of the holding is that facially neutral laws that are applied in a discriminatory and unjust manner, okay, violate against between persons that are similarly situated, violate the 14th Amendment's Equal Protection Clause. Once more, okay, facially neutral laws that are applied in an unjustifiably discriminatory manner between persons that are similarly situated violate the 14th Amendment's Equal Protection Clause. Or, a simple summary, facially neutral laws that are applied in a discriminatory manner, okay, violate the 14th Amendment's Equal Protection Clause. All right? Facially neutral laws that are applied in an illegally proportioned manner against persons that are otherwise on the same playing field are obviously and clearly in violation of the 14th Amendment's Equal Protection Clause. Okay? So when these neutral laws are applied in an unjustifiably discriminatory manner against people who are similarly situated, they violate the 14th Amendment's Equal Protection Clause. Now that we're clear, I conclude. And I thank you so much for listening to this video. If you have any questions or controversies, you can leave them down below and I'll be happy to answer them, okay? If you've not subscribed to my channel as of yet, please do so now. It would be greatly appreciated. And, if, there's anything, that you felt that you learned from this video or insight that you got from it in general, drop me a like. All likes and all subscriptions matter. So I thank you again for listening. Take care, stay safe out there, and I will talk to you at the next video. Peace.